Issue: whether a claim by an individual who has occupied and cultivated the lands designated under the Land, Group Settlement Areas, Act 1960, by FELCRA Berhad without any formal agreement, registration of names or gazettement of lands, ought to be struck out for lack of locus standi. These are the facts. This is a legal case involving the appellants who were original participants selected by FELCRA Berhad to develop a piece of land known as Kawasan Rancangan FELCRA Bukit Tindak. Although the land was not officially gazetted, they claim to have initially been allocated 6 acres of land each, which they occupied and cultivated with crops such as oil palm and rubber trees for over 30 years. In 2014, the acreage allotted was allegedly reduced to 3 acres per participant, which led to a dispute that was dismissed by the courts. Later, the respondents felled rubber trees planted by the appellants without their knowledge or consent, which led to a lawsuit seeking damages and compensation. The respondents argued that the rubber trees were their property and that the appellants had no legal rights over them. The High Court allowed the respondents' application to strike out the claim on the ground that the action was obviously unsustainable, as the appellants lacked locus standi to maintain the action, which was affirmed by the Court of Appeal. The appellants appealed the decision, allowing the appeal. The Land, Group Settlement Areas, Act 1960 sets out terms, conditions, restrictions, obligations, and arrangements for the opening up and development of state lands through group settlement programs. Tracts of state lands are declared as designated areas and can be declared as group settlement areas, which can then be declared as rural or urban holdings. Eligible participants are invited to occupy the holdings and clear the lands allocated for cultivation of specified crops. Participants live in these group settlement areas and form pioneer generations of families. In the appeal, it was acknowledged that there was a group settlement area called KRBT, and the question of whether it had been gazetted or not would be determined at a full trial. The respondents did not deny the occupation of the appellants in the area and were aware of their participation. The appellants had occupied and cultivated the land for over 30 years, and their occupation was in expectation of title under the Act. The respondents did not argue that the appellants were illegal occupants. The matter of the felling of the rubber trees arose during the pendency of Suit 1. Hence, the issue of res judicata did not arise. The controversy was about the selection process for the appellants to occupy and cultivate lands designated under the Act, by FELCRA Berhad without any formal agreement, registration of names or gazettement of lands. The appellants cultivated rubber trees for a long period and the question was whether they had any rights to the trees and were entitled to compensation. The matter required a full examination at trial as the appellants had a reasonable cause of action and the issue was substantive and required proper determination. The lower courts had summarily disposed of the matter, which was not appropriate. To know more,